It's not unusual during the holidays in particular to have an uptick in calls that we get from clients or new folks or whatever, thinking there's urgency to get in, and a lot of it is because there's family members that don't live, with the loved one that are coming in from out of town and don't see the person on a regular basis, and all of a sudden they see a stark change in grandma or grandpa or mom and dad or whatever, and they think, wow, something's really amiss, and so we need to go in and get something taken care of right away. And so it's not unusual towards the end of the year to have a real ramp up in activity, to put things in place to help whoever it is that is experiencing the challenge. But as far as diminished capacity, there's lots of things that people ought to have in place just to have a good, well-rounded plan. And certain things are in place to contemplate if you die. Obviously, everybody knows what a will is. A lot of people know that a trust is an option to take care of how you want your affairs to be handled after you die. But there's lots of things that are good to have in place that aren't in contemplation of death, but are in contemplation of an unexpected illness or accident or something that occurs, so that you provide alternate decision making, and you decide who that is rather than having some judge decide who that person ought to be and what your wishes are. And judges are very busy and they see a snapshot of your life and they're trying to do their best, but it's better for you to decide how you want things to play out, if you were to have that unexpected event occur. And so the things that you want in addition to a will or a trust in contemplation of death are you want a durable power of attorney for financial decision making. And so what that does is, if you have an accident or an illness and you're not able to make financial decisions for yourself, you designate an attorney in fact and typically a successor or two to make those financial decisions for you should you not be able to. And it could be simply, paying my bills, making sure my taxes are prepared and paid, and monitoring my investments and that sort of thing. It could be just the very routine things that you would normally do but for the illness or the accident. And so you want to make sure that you have that primary person designated. In most cases it's the spouse. And then you want to have a backup because, a lot of times, spouses are traveling and they get in a common accident or something like that, and so you want to provide an alternate, and maybe more than one. It depends on how far you want to plan out, but at least have that in place so that you have someone that can immediately step in and start making financial decisions for you. What it avoids is if you don't have something like that in place and something tragic happens, then you have to go through a court process, and you have to get somebody appointed as a guardian and or conservator. The guardian is somebody who's appointed to take care of your person. The conservator is somebody to take care of the estate or your money. And so if you don't have a power of attorney in place and there is no one that has legal authority to make decisions, then you have to go through this court process and you have to get the judge to decide. And of course that's more expensive to go through a court process. It takes a little more time, and there's no clear designation again as to who you would want to do that. And so sometimes you line up siblings that are saying, well, mom would have wanted me to do that. No, mom would have wanted me to do that, and it pits people against one another, and it gets things a little ugly at a time where there's already stress because some unexpected event has occurred. So a lot of this is pre-planning, to be good to yourself and to be good to your family, to be prudent as far as who, you would want to do that. It kind of takes some of that dynamic out of it and just allows you to deal with whatever has occurred. With the power of attorney, the power can come into effect in one of two ways. Either the power can be immediately effective, and so if something happens, you don't have to do anything, and the power is immediately there for someone to go ahead and act on behalf of the person who's granted the power. Or the other alternative is that the power springs into effect. It's called a springing power of attorney. And with the springing power of attorney, there has to be some determination, typically by a physician, that the person no longer has the capacity to care for themselves. And so you typically, look to the primary care physician. They all know, as Dr. Scott would tell you, they could do a mental examination of the person, and they can tell you whether or not, because of whatever the illness is or the accident or whatever, that they don't have legal capacity to take care of themselves or their affairs. And so once that's been done, then the power springs into effect. And so it really depends on what the person wants. If they want that power to be immediate, a lot of people aren't too concerned if it's with a spouse, because typically a lot of your assets are already jointly make decisions for one another. But if it's for a child, or if it's for maybe a non-family member, or not an immediate family member, maybe they want that buffer to make sure that they aren't intruding before that determination of incapacity has been determined by a physician. So when you look at that financial durable power of attorney, determine when you want that to become effective in one of those two ways. Okay. Questions about that? Okay. Another document you want to have in place has to do with your healthcare decision making. And lots of people throw out different words for these things, like a living will, or a power of attorney for healthcare, or an advance directive. And so it's kind of important to understand maybe a little bit of what each one of those does. In Nebraska, statutorily, we pretty much now have an advance directive law that kind of encompasses all these things. And it's meant, all of them are meant to do primarily two things. The first is to have the person give a clear statement of their intent and their wishes should they become in a persistent vegetative state, which is legally defined, where they no longer have any functioning such that they're going to pass naturally. And the person wants to have a statement of their intent as to whether they do or do not want any extraordinary life-sustaining treatment. And so it has a statement of their intent of what they do or do not want to have happen if they were to be in that situation, okay, first of all. And then secondly, you want to then appoint someone as your healthcare agent. And it's important to have that second appointment of healthcare agent for a number of reasons. First of all, again, when you're in a difficult situation where you're dealing with stress because of something that's happened, if you designate the person to have access to your health information and to confer with your medical providers, you want that to be a smooth process. You don't want to run into a situation where someone is telling you don't have the right authority, and so I'm not going to release medical records to you, or I'm not going to allow, or I can't talk to you about the person's situation. So you want to make sure that this document is carefully crafted so that it's got the HIPAA waivers in there, and it's got the right authorization so that you can interact with the people to find out and truly assess what the person's situation is, and then carry out what their wishes are in the document. And again, you appoint a primary health care agent, and then you appoint a secondary health care agent. You always want to make sure that, if something's happened to your primarily appointed person, if they were to die or become incapacitated or whatever, that you've got a backup, because unfortunately sometimes if you don't, and then the primary person who's made the document becomes incapacitated and they don't have an alternate, you're stuck. And so you're again running to a judge to try to figure out who would they have wanted next in line if someone has unexpectedly, is deceased or incapacitated or resigns or whatever the case may be. So again, financial power, durable power of attorney, an advance directive with an appointment of a healthcare agent. Those are key things to have in your toolkit, in your estate planning toolkit. Couple other things that come up with families who have a loved one who has Alzheimer's disease or diminished capacity, or for that matter is incapacitated because of another disease or condition, is if they have a caregiver, whether it be in-home caregiving or they're staying in another family member's house and they're caring for them there. Sometimes you see families get into trouble with lack of communication about, what's the compensation, what are you supposed to be doing for that person, it's best to maybe get those things delineated in a caregiver agreement. And you see this happen a lot of times where there's a lack of transparency, in particular among the family, and some distrust or whatever, and especially when there's a family member providing the care and they're getting compensated. Sometimes people get a misconception about that, and so it's better to first of all be transparent with everybody, and then get it in writing, and delineate what all the duties and responsibilities are, and then put in there what the rate of compensation is, so everybody has an understanding of what that's all about. And so we're doing more and more of those, just because it provides a memorialization of what the arrangement is, and people can weigh in on it on the front end of it rather than questioning it at the end, and having siblings at each other's throat for one or another reasons. So we're doing more and more caregiver agreements. Another document that we provide to our clients is called a letter of instruction. And this is just basically something for the client to take, and it basically allows them to delineate their last wishes. And it can be, they can plan their entire funeral, their hymns, their pallbearers, on and on and on, where they want their memorials to go. But it's a good way to have the person put all that down and plan for it, keep it somewhere, rather than the family trying to get together and figure it out at the time. And if you can get the client to do that and put it in the toolkit and everything, it just makes the job much easier later on. And if they can do it, in the early stages before diminished capacity and everything, at least it gives good, clear guidance to family. For a lot of those issues. So those are some of the legal documents, that I would suggest, meeting with families that are dealing with issues, especially, planning for accident or diminished capacity, someone with Alzheimer's disease and that sort of thing. It will give you a good legal structure to plan for, most any contingency that might come down the road. Now there's some tips that I'll throw out there, because we get people that come in and their crisis, they want to be your crisis, and so the first thing is you need to assess how bad is the crisis. I mean, again, you get the child who maybe lives out of state and visits maybe once or twice a year, and they come back and they see significant change in the person, and wow, they think we need to get in and see Tom right now because we got some serious things going on with grandma and grandpa, mom and dad, and whatever. And so you need to assess really what the situation is first. I mean, is it something that really is truly a crisis from a safety standpoint of the person? Is something that really needs to be done because they aren't able to take care of themselves and feed themselves, and they shouldn't be living alone, or somebody's taking advantage of them, or stealing their money or whatever. So assess the nature of the crisis, because a lot of times their crisis is something that could, you can take a step back from, be a little more collaborative with the rest of the family and take some educated steps towards a better solution. And so part of the job is to do that assessment and really get a good handle on what's going on. So assess the extent of the crisis, and then I always tell my folks, please try to be as transparent and cooperative on the front end as you can. And this applies to mom and dad or the kids or whoever's doing the plan, is why hide it? Why hide the ball? Why not tell everybody what you're doing up front and who you're designating in whatever capacity and why you're doing it, and how you've got it all laid out and how it's supposed to be implemented, and then it can be changed, at any time if something changes or whatever. But lay it out there, let everybody know what you're doing so that it's not a surprise. And then if there is some pushback, which a lot of times there is, mom and dad or grandma and grandpa are there to defend it, and typically that's a lot better than trying to guess what mom and dad or grandma and grandpa would have said. So it's good to have transparency and try to get that buy-in from everybody if they'll all agree to it. And one thing I forgot to mention, which is important on the advance directive and the healthcare document, is once all that gets done, make sure that somebody, either the lawyer's office or some family member, make sure that the key person who needs to know that they've done that knows they did it, and that's the physician. You know, we make sure that a copy of the advance directive gets into the person's medical file, so that their primary physician knows that they've done that, knows what their wishes are at end of life, and knows who the people and the contact information is for all those healthcare agents. So all that information's in that document, so it's in their medical file, so if something happens, Dr. Scott knows what their end of life issues are and who the people are that need to be contacted as healthcare agents. So make sure that loop gets closed, with it not just sitting in the lawyer's office or sitting in the safe deposit box or whatever. Make sure that gets disseminated to the key people who will need to have access to it once it gets implemented. Okay. This is a pretty neat little pamphlet. It's not specific necessarily to Nebraska, so understand that, but it's pretty good, and it kind of covers some of the things I was just talking about. And so it's kind of a good little thing to take home, and it does have a couple things on how to find a lawyer and the things that you ought to take with you when you go meet with your lawyer. It's always good to have those key things and try to minimize your time with the lawyer. It's less expensive that way. But take the key things with you. And this has a pretty good list of some of those things that you might want to take with you when you go meet with the lawyer. So that's a pretty good resource. I guess one final thing is try to build a team around your loved one, which would include not just the professional people, but their friends and their neighbors and their other caregivers, and make sure that team is as strong as it can be. I take care of my father-in-law's in the late stages of Lou Gehrig's disease, and so I'm his care coordinator from afar. They live in Loveland, Colorado, and so I manage his long-term care insurance, his Medicare, his Medicare supplement, and his caregivers, and all that sort of thing, because I have a little bit of knowledge how to bring that to the table. But I can't take care of his daily needs from Harney. And so you need to make sure you assemble that team of all those people, from the neighbor boy who comes over and rakes his leaves to who bathes him. These are all people that are out there that are all within your sphere of your loved one, that you just need to muster all those resources so that he or she is cared for and nurtured. And so, you can obviously include the professionals, but the people that are there day to day, they're caring for them or whatever is very important as well. So that ought to be a focus of the dynamic of what you put in place. So I'll take questions if anybody has any questions here.
Go back to the beginning on the power of attorney in fact. Wasn't there some type of a legislative changes this year that changed the power of attorney documentation or documents? Are they more specific than they were previously, or the ones that are currently being used?
There was a change in the law, and what they did is they implemented a uniform durable power of attorney act, and they tried to make it simpler. They tried to create kind of a generic form, is what they tried to do. And so you can go to the statutes now, and there's a recreated form that if you use that, it'll be recognized. And so that's what the new change in the law was to implement this uniform durable power of attorney act. What they tried to do also is simplify it to the extent that sometimes, and you would have seen this in banking, sometimes you get a 20-page power of attorney, and you need someone like me to figure out what it says, and whether they can do this, that, or the other thing. I mean, we're trying to make it simpler so that if you use this form, the law would say that they can do A, B, C, D, and E, you know, and make it simpler for a layperson to look at that and say, well, it was implemented as a uniform verbal power of attorney, so yes, they can access the safe deposit box, or yes, they can write checks on behalf of so-and-so. So that was the intent, was to implement a uniform law that would try to make it simpler, and you wouldn't have to get, you know, 10 different versions of a 20 or 30-page document that, you know, only some law professor could figure out. Yes?
I have POA for both financial and healthcare, but I'm a little confused on this. It's a two-part question. The statement of intent or living will or advance directive, are those all one and the same thing? That's my first question. And second, is that a form that you can get somewhere, or do you have to go to an attorney? Because we've got the two POAs, but we don't have anything regarding that.
A living will, people think of a living will typically as that statement of what your end-of-life wishes are. You know, a living will is, if I'm in that persistent vegetative state, I do not want extraordinary life-sustaining treatment except pain medication for my comfort only. That would be a typical living will. The power of attorney for health care probably has some language in there about that, but the power of attorney for healthcare is specifically intended to appoint someone, to appoint, you know, an alternate decision maker for healthcare. The advance directive tries to encompass all that into one document. Okay? So it kind of depends on when these things are created or who does. You know, lawyers do things a little bit differently depending upon what their practice is or when they did it. It used to be, years and years ago, it used to be in Nebraska, it didn't even have a law that recognized a living will. And it's only been in the last probably 10 to 15 years that we've statutorily even recognized those. So if it's an old one, if it's an old living will.
No, this is just last year.
Okay.
So it probably already has that encompassed in it?
Yeah, most likely.
Okay.
Most likely. And there are places where you can find these forms in various places. The one thing I would caution you is just make sure that if there's something unique or distinct about Nebraska, that it complies with that from merely the way it was executed. Sometimes you need two witnesses and a notary. Sometimes you just need the notary. And so, you know, even just the execution of it is important to understand that it's done right. But you can go, for example, you can go to the gift shop at Good Sam, and you can buy the 5 Wishes booklet. I don't know if any of you are aware of that, but you can go to Good Sam, and they have a booklet called the 5 Wishes. I've seen it. It's a pretty detailed document that you go through, and you really get personal with what you want to have or to have not have happen if you're in a number of different situations end of life. And so there's something like that you can go and just buy for, you know, $10 or $20 or whatever it is, and just fill in the blanks and fill it out.
Thanks.
Yes, Ron?
Just to confuse things even further, there's now a pretty widespread policy going on with nursing homes, and it's called POLST,
I'm aware of that.
Physician-Ordered Life-Sustaining Therapies. So rather than just saying, I don't want to be in a vegetative state, please don't resuscitate me, now the family shares these kinds of things like, do you want IVs or not? Do you want antibiotics or not? Do you want to go to the hospital or not? Do I want a nasogastric tube? Those are things that the physicians used to order and say, it looks like this is the right thing to do. Now family members want to share in that responsibility and that guilt on occasion, and that's there if you want that. I think it's very helpful because my partner may put somebody in the hospital and say, but it said right here, don't put me in the hospital. And so that's not going to happen the next time.
Right. I'm aware of the PULSE program. It's I think it started in Oregon, Washington.
Nebraska was a hotbed in Nebraska.
Right.
But yeah, it's I don't know where it's all in effect, but you got to think of it, it's probably not a legal document, but it's just another expression of fine-tuning what are these extraordinary, some people would consider an IV as being extraordinary, some people would not.
Right. Well, it's much more medically intensive
Yes.
than a legal document, and it gets much more specific about, I think, specific end-of-life, procedures. Any physician, is going to do anything possible to save someone's life unless it's absolutely clear that they didn't want, whatever. And so the Pulse program, I think you'll probably hear more and more about that because I know it's out there. I know Columbus is really into it, and I know it's infiltrated Kearney. And people are talking more and more about it, and so it'll be interesting to see how that develops and then how that interacts with the people that are doing the legal implementation of advanced directives and that sort of thing. But if you hear about Pulse, it's a similar type thing, but coming more so driven by the medical side of things than the legal side. So it'll be interesting to see how those things go.
And it's interesting, I've been working in Falls City and Wahoo. Neither of those communities said, do you have Pulse? They said, what's that? We don't know. So it's not everywhere.
Yeah. Good question. Yes?
You indicated that the springing version comes into effect when the doctor determines that the individual can't care for themselves. I thought the automatic version did the same. I mean, when does it go into effect? Does it not have a determination?
Well, that gets it gets to be sometimes a little tricky, especially when it's not a spouse. Especially, like if it's not a spouse and the child is getting ready to do that, it gets a little tricky because as far as the implementation of it, there's no requirement in the document that says you have to go get the physician's letter. Okay, so it would be effective, but then it's always tricky as to when does the person that gave the power ready to give up, and when does the child take over? And so it's probably different in every scenario. And so if it's something that's going to be contentious, then it's always a good idea to have the mental status exam done, just to be sure. If there's a diagnosis, for example, of dementia or Alzheimer's or whatever, that's always good to get that documented. And then, if the person really gets agitated, then that person who's been designated as the attorney, in fact, really needs to just step up and take control. Okay, and so, but there's nothing necessarily in the document that requires that you have to go get the letter like the springing one does. It gives that immediate grant.
Kind of consent.
Yeah, it's kind of consensual, but everything is that's where there's gray, and so how that handoff happens, sometimes can be smooth and easy, and somebody's ready and understands that, okay, I want son or daughter to start doing that, or it could be tough if there isn't that realization that the capacity is diminished. So then you get the medical information and data, and then the person just goes ahead and kind of pulls the trigger and does it. Yeah.
We got the answer, but I don't think we heard the question back there.
Okay. It's the difference between the springing power of attorney and the one that's immediately effective. With the one that's immediately effective, a lot of times there's a tricky trade-off as to when does that actually go into effect. Okay, if you don't have to necessarily go get the medical letter from the physician. Good. Sure.
It's not a question necessarily, but in a situation where you may have siblings that don't get along, I'm assuming you may want to have the letter, even if you have not the springing, but the regular power of attorney, just to protect the one that's taking charge of it.
Yeah, exactly. I mean, we always get to see the worst cases, where people are at each other's throats or whatever. And so, yeah, if I'm counseling the person who's going to implement the power of attorney, then you want to make sure that they're as bulletproof as they can. And so you have them, go in and get, a mental status exam or whatever. And so they've got, documentation that they know that they can pull the trigger on it. Because if they know that siblings are going to be after them, then they need that back. The other thing too is what we do is we send a letter to the person who's going to be the attorney in fact, very detailed letter, and explaining to them their legal and fiduciary obligations as an attorney in fact, so that they understand what the ramifications of that are. Because you probably read in the paper where there's been abuse from either a guardian or conservator or attorney in fact, where somebody's actually stolen money or done really bad things. And so there's been a lot of new laws implemented because of that. So it's always good practice to tell these people you have a fiduciary obligation to your loved one to act as if they would, as if that's your money, and not obviously respond with it or steal it or leverage it unwisely or whatever. And so at least it puts them on notice if something goes wrong, that they can be held legally accountable.
If you have any more questions, can we just ask? Is he going to be leaving?
Yeah.
Okay. Let's wait on some more questions because we have 2 more panelists to give presentations, so we hang on to that. I'm sure there will be more as you can think about it. A lot of information. Excellent legal suggestions. So hang on to your questions. Let's get our other 2 panelists in here to do their presentations. That was excellent.